We had a Navy veteran that was a diver, and he was doing a search and rescue mission. I think it was a civilian boat or something. I'm not sure of all those facts, and they're really irrelevant to this analysis. Diver out in the water doing a search and rescue mission, and while doing that, he gets separated from his group of divers. He's out in the ocean in the middle of nowhere, and that apparently puts, fear of loss of life. Logic makes sense to me, right? You're out in the middle of the big blue ocean, or maybe the big black ocean if it was at night. I don't know. That's got to be scary. Even the way they do it in Hollywood movies is scary. So in reality, it's got to be scary, put you in fear of loss of life. He said that that was the stressor event for his post-traumatic stress. And that's really all you need for a stressor event, at least for a diagnosis of post-traumatic stress disorder. You need to have an imminent fear of bodily harm or injury, loss of life, or loss of life to somebody who's close to you. And I'm really, really overgeneralizing that definition. But those are the sorts of things that can cause the medical condition of post-traumatic stress disorder. So he went in and, if you are a non-combat veteran, if you're a veteran of any of the branches and you did not serve in a combat capacity, and I'm not talking about wartime, I'm talking about actually bullets zipping around your head, artillery rounds coming in over you, mortar rounds splashing to the left and to the right. That's the kind of combat environment that you've got to be in to get the lightened burden of proof. If your allegation of the stressor event is consistent with your MOS and the type of service that you had, you're going to be presumed to be credible as far as your stressor event. And that's fine. Non-combat vets have to go a step further, and they have to have evidence that corroborates the stressor event. Now, corroborate, just another $100 lawyer word, but corroborate basically means show us it's for real. Now, you don't have to prove it definitively when you corroborate a fact. Again, the burden of proof in these cases is at least as likely as not. So it's a pretty low burden of proof. So you just have to show one feather past 50% or sometimes even 50% to call in the benefit of the doubt rule. This particular veteran, what he did was he had a diagnosis of PTSD from his doctor. He had his testimony about this dive incident, the search and rescue dive incident and what happened. And then he had a newspaper clipping that referenced the particular ship and that there was a search and rescue event for it. I think it even went that far. It might not have, to tell you the truth, but there was a newspaper article about the ship and some folks going overboard. Well, they denied the claim for PTSD, saying that the veteran did not corroborate his stressor event. And they appealed. The veteran appealed through the board. The board affirmed that denial, went to the Veterans Court. The Veterans Court looked at it, and the argument that they made at the Veterans Court was that when you're corroborating a stressor event, and when I say they, the veteran and his team, made the argument that when you're corroborating a stressor event as a non-combat veteran, you only have to corroborate the event. You don't have to corroborate that you were a part of it. That's up to the doctor to say you were part of this event because they're using that stressor event as a diagnosis. It makes sense when you think about it. Unfortunately, the court came back and said, no. We're going to look at the actual reading. And I'm sorry, I think this was actually the Fed Circuit. I'll defer to what I wrote in the blog post. It's Friday afternoon, and it's been a very, very long week. But the court came back and said, no. When you prove or corroborate a stressor event for a non-combat veteran, the proof that you have to provide is corroboration that the event happened to you. You don't have to prove it beyond a shadow of doubt. You don't have to provide clear and convincing evidence, but you do have to show evidence that it's at least as likely as not that it happened to you. And as a non-combat veteran, that's always going to be more than just your testimony. You need to corroborate your testimony either with somebody else who was there, with some sort of article in the news. I mean, and we've seen it all the time. I've had cases where I've seen the article in the file that mentions that so-and-so was part of a particular mission where several people died, and that's enough to corroborate the event that the veteran complains about, saying that he witnessed the death of certain people in a certain event. But the bottom line is, when you're corroborating your stressor event in a PTSD claim as a non-combat veteran, you have to show that the event happened to you.